Good evening, sir. This side Tanya Katyal, legal intern at Indian National Bar Association, welcoming you to this interview. It is my immense pleasure to have you with us, expressing my humble gratitude and regards to you on behalf of the entire team of INBA. With your permission, may I start with the interview?
Sure.
Thank you, sir. So starting with the introduction of our guest of honor, Advocate Advait Sethna. He is one of the eminent counsel at the pristine Bombay High Court and Supreme Court of India since the past 15 years. He has appeared in the many important matters concerning constitutional law, media laws, commercial laws, and arbitration. He has been the counsel for the Films Division of India and Central Board of Film Certification in many matters on films like Urta Punjab, Padmavat, and Kedarnath, among others. He has appeared in several important landmark cases, one of them being the famous Vijay Mallya case, where he represented as special counsel for the Service Tax Department. He has various articles in his name, which are published in the Forbes magazine. It is my immense pleasure to have you, sir, for this interview. So my first question to you is, sir, that as an expert in arbitration and administrative law, how do you see this field in the present scenario, and what, according to you, would be its scope in future?
Well, Tanya, as far as arbitration is concerned, there are two facets to your question. One is arbitration and one is administrative law. These are two different concepts. So let me first talk a little about arbitration. Now, arbitration can be segmented into kind of the pre-COVID and the post-COVID scenario or situation. As far as the pre-COVID situation is concerned, you see, we are all governed by the Arbitration Act of 1996, which has seen two substantial amendments, one in the year 2015 and the second one in the year 2019. According to me, arbitration is coming up in a major way. Particularly as far as the field of commercial law and commercial transactions is concerned, we are seeing a big leap in arbitration as an area of specialization and as an alternate dispute resolution for the quick resolution of disputes. In the post-COVID situation, in the pre-COVID situation also, in fact, things were different, and post-COVID situation, the difference primarily being that now arbitrations are largely conducted through video conferencing. So technology is playing an integral part and an important role it imparts in the conduct of arbitration proceedings. India as a country, through various arbitration proceedings arbitration centers like the Arbitration Council of India, which has got a recognition through the 2019 Act, formal recognition, is now having the requisite platform in terms of technology, which enables parties to connect all over the world, particularly in cases of international commercial arbitration. So as we are moving to the concept of Vasudhaiva Kutumbakam, that is one world is one family, right? So that concept is manifesting, largely through technology, and technology enables parties. Parties need not travel. So the travel, from an expense point of view, parties need not travel to other countries, and they can do arbitrations and ensure that the arbitration is conducted smoothly through the aid of technology.
So this question,
yes.
Another question also. So
yes, sure.
This interface of court proceedings and technology due to pandemic leading to the virtual court in India?
Well, that's the favorite question today, particularly in the situation as the world order is changing. I must tell you something interesting, Tanya. Arbitration, I'll just go back a little. I was really intrigued to know that arbitration actually has its roots in the time of King Solomon. One of the first arbitrations in the world started, with two ladies who were claiming custody on a child, and this dispute was referred to King Solomon, who acted as an arbitrator. And then subsequently, Athens, the island of Athens, the supremacy over the island of Athens was also decided in an international commercial arbitration. So this is how the international commercial arbitration actually saw its rise from 637 before Christ. And we have really moved a long way. Now coming to the question of video conferencing, which is, or the electronic means and technology, which also plays an important role in arbitration. Today, courts are also getting equipped with technology and the means to connect, which we call as virtual hearings. Now, as legal luminaries like Justice Chandrachud has said, who is the chairman of the E-Committee, has said that it is not to dissuade we dissuade people from thinking that this is going to completely replace, or technology is going to completely replace physical hearings. That can't be done. Right? So technology is seen as a complement, as an essential tool or an essential ingredient which will enhance the both the speed and efficiency of resolution of cases at both at the court level as well as from the point of view of lawyers as well as judges.
Indeed.
And here I must add that even artificial intelligence is developing, and that is being used as a primary measure to reduce the dependence on human beings, which have their limitations, so that in certain cases like paroles, etc., particularly in criminal cases, artificial intelligence can be used as a tool, not as a substitute, to ensure that the cases speed up and the backlog is ultimately reduced.
So, sir, my next request would be to please share your experience in the famous Vijay Mallya case.
Oh, that is one. I am not senior as much, but I was fortunate that when I was really a junior, say when I had completed about 8 or 9 years of practice, I was bestowed upon this huge responsibility. And I started, this was one of my first cases, fortunately, that I got right in the magistrate's court. I handled Vijay Mallya's bail application, and I had stalwarts on the other side facing me, like I don't think there's any harm in naming them, like the likes of Mr. Amit Desai, Abad Ponda, and several others. And it was very difficult, in terms to face these legal luminaries at that stage. And we were appearing for the department, and you know how the shortcomings of the department. But fortunately, of course, Vijay Mallya got bail. But I must also tell you that we were successful as the first case in the history of Service Tax Department to get a non-bailable arrest warrant followed by an extradition order, which was passed by the magistrate's court. I must tell you that the procedure for extraditing a person, a fugitive, outside India for non-payment of tax dues was not even known to the magistrate or the criminal court. And it was a first-time experience for the judges that there is an entire procedure which is laid down by the Ministry of External Affairs. And you won't believe, the judge has to sign a 1,500-page dossier, and every single page has to be signed by the judge. And we did this. We used to go to the judges because the judges used to get transferred. So we used to go to the judges in the evenings and we used to have these things done. And finally, it reached where it had to in London. And we were successful to carry out carry out this job of extraditing Vijay Mallya in the service tax case as well, along with the cases filed by the CBI and the ED.
Indeed, it was a great achievement for you, sir.
Yes.
So the next question would be, what is your opinion about the current redressal mechanism prevailing in India?
Tanya, that's a very broad question, and you have really limited my time, as courts are doing now, to answer you. Redressal mechanism, as of today, it is at various levels. You have an alternative dispute resolution mechanism, that is negotiations, mediations, arbitrations. Then you have adjudications, which more is towards the court systems. So I would say that the awareness of ADR mechanisms is on the rise. Earlier in the early 90s or even in the early 2000s, we were seeing that the awareness for ADR mechanisms was not as much prevalent in the rural areas. This is one of the reasons for the redressal mechanism not going to the common man. But now that awareness is increasing, everyone doesn't run to the court for every dispute or every small dispute which can be settled out of court. So this is a trend which is, I see that it's a positive shift in the process which we are undergoing, or which we are seeing a positive transformation in a sense. As far as the court system is concerned, of course, there is a huge backlog, goes without saying, but I must give it to the judiciary most humbly, in my most noble capacity, that the judiciary is trying its level best to ensure that the backlog reduces, particularly at the apex court level and the high court levels. And because the apex court and the high court is taking a lot of pains in ensuring that adjournments are less, in ensuring that cases are decided at the admission stage itself, so that people don't have to wait for years together. Even now, civil suits which were taking years, we always, it is said that we don't know whether we will able to see the light of the day as far as a civil suit is concerned. But in those cases also, priority is being accorded. So various systems and priorities, senior citizens are given a lot of priority. So that is a positive development. So there is a positive attempt being made by the judiciary and also by the lawyers, which are basically, two sides of the same coin, in ensuring that the backlog reduces and we are basically moving towards less burdening the judiciary with the cases that are there.
So my last question would be, as an active member of the legal fraternity, what would be your suggestions to the law-making body of India in order to curb the increasing economic offences?
Well, that's a very good question, I must say. If I have to suggest, my suggestion would be there have to be fast-track courts as far as economic offenses is concerned. You see, in criminal jurisprudence, there is a clear movement from the age-old crimes to new crimes. As we become modern, you see, crimes are also becoming modern. See, in the days, you see, when at the time of our grandfathers or even great grandfathers, nobody knew what a cyber fraud would be, or nobody knew what an online fraud would be. So all this is basically modern age crimes. Now, these economic offenses, and the Supreme Court has in fact said that these kind of offenses are a menace to the society. So what I believe is that as this really poses a huge challenge to the judiciary, and the monetary system and the economic backbone of the country is affected by these economic offenses, I feel that the courts should try it on a fast track basis, and there should be a time frame for fixing the time of the trial. That is right from the day the trial begins to it ends in the Supreme Court. If it is done in a time-bound manner, then that would considerably reduce the menace to a great extent. Also, there should be curbs on people moving out of the country. You see, the trend started, of course, with Mallya, then followed by Nirav Modi. Actually, it started, if you recall, in the early 90s, when, one of these, Nadeem Shravan, if I'm not wrong, at the Gulshan Kumar's time, one of them fled to London, and he's still in London. So therefore, you see, people, this is fleeing away from justice. So I believe that unless and until the trials are over, you see, these people should not be allowed to flee from justice, to abscond, and of course, ensure that the trial ends, you see, as expeditiously as possible, so that justice is ensured in a speedy and efficient manner. I'm sorry, I'm not here. I'm sorry, your voice is not.
Thank you, sir, for your expert and enlightening words. Would you like to give any other message to our viewers?
Well, I would definitely like to say a couple of things. One is very quickly. One is that as far as I would implore the judiciary that please, as far as crimes against women and children are concerned, there must be reforms, and the reforms must be seen. My heart goes out for particularly for minors who are molested, who don't have voices, and they are molested, subject to rapes, and these people, I feel that whenever if the accused is being caught, those trials should end, according to me, in a period of 3 months, not exceeding 6 months. It should not happen that a minor becomes a major and the trial is still on. So my
in Nirbhaya.
Yes, in Nirbhaya case and in so many cases, because unfortunately, we all thought that Nirbhaya would raise an alarm, but unfortunately it has not. So probably we need a deterrent in this case, and we need speedy and rather speedier justice, and to ensure that the accused are booked as quickly as possible. And my second suggestion to all juniors, particularly those who are working, I myself consider myself as a junior, but a little junior to me would be that please come to counsel practice. That is where the actual law in practice and in motion is. Thank you very much. Thank you very much.
I would like to express my gratitude once again on behalf of INBA and for such an enriching interview. Thank you, sir. With your permission, I would like to call down this interview.
Sure. Thank you very much, Tanya. Thank you.
Thank you so much.